When a heavy ceramic mug slips from your hand and shatters on the floor, we call it an accident. In everyday life, accidental harm happens constantly. But under the common law, suffering an injury or financial loss does not automatically entitle you to compensation from whoever was standing nearby. To force someone else to pay for your misfortune, you must use a specific legal mechanism, the tort of negligence. This system is engineered to shift the financial burden of a loss from the victim to the perpetrator, but only when objective criteria are met. Courts in the UK and Australia approach these claims not as subjective moral judgments, but as a strict sequential logic gate. A plaintiff must prove 4 elements. First, a duty of care. Second, a breach. Third, factual causation. Finally, remoteness of damage. The rules of this algorithm are absolute. If a plaintiff fails to prove even a single one of these 4 nodes, the entire claim collapses and they recover nothing, regardless of how severe the injury might be. We begin with Node 1, duty of care. Before a court evaluates whether a defendant acted poorly, it asks a threshold question. Did the law require them to act carefully in the first place? The baseline answer for both the UK and Australia comes from the 1932 landmark case, Donoghue v. Stevenson, which established Lord Atkin's neighbor principle. The neighbor principle dictates that you must take reasonable care to avoid acts or omissions that you can reasonably foresee would likely injure your neighbor. In legal terms, a neighbor is anyone so closely and directly affected by your actions that you ought to have them in mind. While this 1932 ruling created the modern tort of negligence, contemporary society requires tighter parameters. Consequently, the UK and Australia have evolved separate, more rigorous tests for establishing exactly when this legal duty exists. In the United Kingdom, establishing a duty relies heavily on the 3-stage Capero test. This diagram outlines the UK approach. For a duty to exist, the harm must be reasonably foreseeable. There must be a relationship of proximity between the parties, and the court must decide it is fair, just, and reasonable to impose liability. Australia explicitly rejects the 3-stage Capero test. Their High Court opted for a different methodology. Rather than using rigid steps, Australian courts employ a salient features approach. They evaluate specific elements like the plaintiff's vulnerability and the defendant's degree of control, working in tandem with strict state civil liability acts. Despite these divergent pathways, London's structured 3-step test versus Sydney's factor-weighing approach both serve the exact same algorithmic purpose. They act as the primary gatekeeper, keeping legally baseless claims out of court. Once a duty is established, we advance to Node 2, breach of duty. The court must now determine if the defendant's actions fell below a legally acceptable standard. The defendant is evaluated against the concept of the reasonable person. This means they are not judged by their own personal capabilities or deficits, but by the fictional standard of an average, prudent citizen in the same situation. This graphic demonstrates the calculus of negligence, the mathematical weighting of risk courts use to determine what a reasonable person would have done. On one side, we place the probability of the harm occurring and the potential gravity of that harm. Against those risks, the court weighs opposing factors, the financial or practical burden of taking preventative measures, alongside the social utility of the defendant's activity. A breach of duty is a failure in risk management. The law does not demand absolute perfection. It demands a rational balancing of risk versus the preventative burden. We progress to Node 3, causation. Proving a defendant acted negligently is legally meaningless if that negligence did not actually cause the specific injury. The primary tool for establishing this link is the but-for test. This timeline visualizes the logic. We ask if the plaintiff's harm would have occurred but for the defendant's specific breach of duty. If we remove the defendant's bad act from the timeline and the injury still would have happened anyway, the causal link is broken and the claim fails. In highly complex scenarios involving multiple causes, such as medical negligence or toxic exposure, both jurisdictions rely on specific statutory frameworks to assess whether the defendant made a material contribution to the harm. Causation serves as the physical anchor of the algorithm. It forces the court to prove an uninterrupted factual bridge between the bad behavior and the broken bone. We reach the final node, remoteness. Causation alone is dangerously broad. A single dropped match could factually trigger a chain reaction that burns down a whole city. Public policy dictates a strict boundary condition. A defendant cannot be held financially liable for infinite, freakish chain reactions. This diagram illustrates the test for remoteness shared by both the UK and Australia, originating from the Wagon Mound cases. It operates on the principle of reasonable foreseeability. The court asks if the specific kind or type of damage suffered by the plaintiff was reasonably foreseeable, even if the exact sequence of events was highly unusual. Remoteness is the algorithm's final failsafe. It ensures that liability remains proportionate to the original negligence and does not stretch into the absurd. Duty, breach, causation, and remoteness are interlocking, load-bearing pillars. Yet this algorithm is intentionally fragile. If a plaintiff fails a single element, like the but-for test at node 3, the line severs. The remaining nodes shut down, dismissing the claim. Whether an advocate is applying the strict stages of Caparo in London or navigating the Civil Liability Acts in Sydney, the requirement is identical. Securing compensation for tortious negligence requires absolute mastery over this unbroken chain of logical proofs.